Hi, my name is Shaye Larkin. I'm a San Francisco bankruptcy and tenant rights attorney, and one of the services I provide to my clients on a regular basis is I help tenants get their security deposit back from the landlord after they moved out and the landlord has taken a deposit illegally. This video is based on California law, and watching this video is not a substitute for sitting down with your own attorney and getting specific advice about your specific situation. Now, one of the mistakes I see landlords making on a regular basis is they fail to offer the tenant who is moving out the opportunity to have a pre-move out inspection. California Civil Code Section 1950.5F requires that within a reasonable time after the tenant has given the landlord notice of their intention to vacate the premises or before the end of the lease term, the landlord must provide the tenant with notice of their opportunity to have a pre-move-out inspection and to be present at the inspection. This right does not arise in some types of eviction cases, such as eviction for non-payment of rent and eviction for creating a nuisance at the premises. The reason for the inspection is to provide the tenant with a fair opportunity to be made aware of conditions at the premises that need to be either cleaned or repaired in order for the tenant to avoid deductions from the security deposit. The notice must be in writing, and there are specific language requirements for the notice. If the tenant requests the inspection, then it must take place at a mutually acceptable date and time, but no earlier than 2 weeks before either the date the tenant will be moving out or the lease termination date. The landlord is required to provide 48 hours written notice of the inspection unless the 48 hours notice is waived by the tenant in writing. If requested by the tenant, the landlord or their agent must conduct the inspection whether or not the tenant is present for the inspection. Upon the conclusion of the inspection, the landlord or their agent must provide the tenant with a written itemized statement showing the items that need to be addressed by the tenant in order for the tenant to avoid being charged. If the tenant has not requested an inspection, then any obligation of the landlord to provide such an inspection is extinguished. When one of my clients comes to me with a security deposit dispute, one of the first questions I ask them is, after you gave your notice to the landlord of your intention to vacate the premises, did they offer you the opportunity to have a pre-move-out inspection? If my client says no, then the case of getting their money back is much easier, because if the landlord did not provide you with an opportunity to have a pre-move-out inspection, then they are not entitled to deduct anything from the security deposit for repairs or cleaning. It's not sufficient that the landlord stuck the notice in as a clause in the lease. The notice must be given to the tenant in writing after the tenant has given the landlord notice of their intent to move out. It cannot be given before. If the landlord did provide a pre-move-out inspection, then the next question I ask my clients is, did the landlord provide you with a written itemized statement or a checklist setting forth the action items you needed to correct in order to avoid being charged? California Civil Code Section 1950.5F2 specifically states, based on the inspection, the landlord shall give the tenant an itemized statement specifying repairs or cleanings that are proposed to be the basis of any deduction from the security the landlord intends to make. If the landlord did not provide such a checklist or statement, then they are not entitled to deduct anything from the security deposit for repairs or cleaning. It's the same as if no inspection was provided at all. If the landlord provided both the pre-move-out inspection and the post-inspection checklist or statement, then the next thing we need to look at is whether any of the items my client is being charged for either pre-existed the tenancy, constitute ordinary wear and tear, or were not caused by my client. For a more detailed discussion on what falls within the ordinary wear and tear category, I encourage you to watch my video on that subject. Now, again, if the tenant fails to request the pre-move-out inspection, then the landlord is off the hook for this requirement. As a tenant, you are far better off requesting the inspection and having it take place than not requesting the inspection at all and getting hit with surprise charges after you move out. That's the pre-move-out inspection, and that's the end of this video. Thank you for watching.